So Article 3 is the article of the Constitution that creates the federal judiciary. Its structure is largely defined by what's come to be called the Madisonian Compromise. There was sort of significant disagreement at the time of the founding as to whether there should be a federal judiciary, how expansive the federal judiciary should be, what kinds of jurisdiction the federal judiciary should have. So essentially what the convention did, and this is what's called the Madisonian Compromise, is it punted. So Article 3 says there has to be a Supreme Court, and then Congress, if it wants, can create lower federal courts. As to the Supreme Court itself, all it says is there has to be a Chief Justice and then as many other justices as Congress wants to create. As to federal jurisdiction, it says that there are certain heads of jurisdiction that the federal courts can have, but there's only relatively few heads of jurisdiction that the federal courts have to have. So basically, the Article 3 is largely in the nature of a punt to the future. And so one of the first things Congress has to do in 1789, after it convenes for the first time, is fill in the blanks. It has to create a federal judiciary. And so we get the Judiciary Act of 1789 as one of the very first laws passed by the new Congress.
It's important to recall when we think about those kind of debates that happened at Philadelphia, that the English judicial tradition, as it developed in England, was quite remarkable. Over the course of many centuries, the English judges strongly resisted the idea that they, in making their decisions, should do anything except apply the law. Now, in a way, that sounds, well, commonsensical. What else should judges do besides apply the law? But in fact, there was a strong pressure that came from time to time from the Crown especially to bend the law to suit his political needs. And there was a strong pressure that came at certain times to adopt certain academic theories from the continent of Europe, according to which judges should follow higher laws, like the natural law, like the divine law, when those kinds of laws came into conflict with merely human law. And the English judges, over the course of many centuries, strongly resisted. They didn't always succeed, they're human. But most important, they developed an ethic that their will, their personal beliefs about good policy, their personal beliefs about justice should not play a part in their decisions. Their job was simply to apply the law.
But actually, it's fundamentally a question about federalism. It's fundamentally a question about where do you want these kinds of issues to be decided, and who do you want deciding them? And the thing that can often be hard for us to remember from the perspective of the 21st century is we think about the Constitution as this almost ancient thing that we venerate, and we have historic homes devoted to the people who wrote it, and we think of it as this long-lasting sort of solid foundation. But in 1789, it was exactly 1 year old, or not even a year old, right? The last state that was needed to ratified in 1789. Meanwhile, there were all kinds of really familiar institutions that did go back centuries, right? So if you're a Virginian, if you're, Madison or Jefferson or Washington, right, you're familiar with the House of Delegates and then the House of Burgesses going all the way back, into the early 17th century, right? And then you've got this newfangled thing that just came into being in 1789, hot on the heels of the failure of the Articles of Confederation, right? So you've already seen one sort of failed attempt at establishing a national government. Now you've got this second attempt. You're not sure if this thing's going to work out. You're not sure if it's a good idea, but your Virginia legislature, your Virginia courts, or your Massachusetts or New York or wherever you're from, and so so this question about who's going to decide these questions. And so in the Article 3 context, it's who's going to decide judicial questions, but same thing in the Article 1 context with legislative questions, or the Article 2 context with executive questions, right? What level this is going to be made at is actually felt fairly keenly by these people, because they're not sure about these new federal judges. They're not sure what they're going to be like, who's going to appoint them. If I'm from Massachusetts, we all know that George Washington is likely to be the first president. Am I sure that I want judges appointed by this Virginian having that much say over everything that happens in my state? So these questions about federal jurisdiction are really questions about federalism, and really questions, therefore, about how tightly knit this new entity is going to be, right? How centralized it's going to be or how decentralized it's going to be.